Good afternoon, everyone. My name is Jason Q. I'm a staff attorney here with the DC Bar Pro Bono Center. Welcome to today's webinar, Onboarding Employees, What You Need to Know in Order to Dot the I's and Cross the T's. Our webinar today will cover a range of employment law-related issues that nonprofits should be aware of when they hire on new employees. So our presenters today will be Alex Malson and Allison Fepelstein, both of the law firm Morgan Lewis. Alex is an associate in the firm's labor and employment practice, and Allison is an associate with the firm's employee benefits practice. We are very happy to have them both here for today's presentation. So before we start, a few housekeeping notes. First, there should be a field in the GoToWebinar platform that will allow you to ask questions during the presentation. We will hopefully have some time at the end to answer those questions, so please type them in if something occurs to you during the presentation. Secondly, you can download a copy of the PowerPoint presentation by clicking under the Handouts tab on GoToWebinar. And finally, you'll be getting a survey later this week that we hope you will fill out to give us some feedback about the presentation. The survey will also include a direct link to a recording of today's webinar so that you can circulate that or return to the material. Okay, perfect. And so with that, I will turn it over to Alex and Allison.
Great, thank you, Jason, and thank you for joining us this afternoon, everybody. We'd like to thank the DC Bar for providing us an opportunity to speak with you today. My name is Alex Malson, and I'm an attorney at Morgan Lewis and Bockius here in DC. I practice in the Labor and Employment Practice Group, and I'm joined by my colleague Allison Fepelstein, who is also an attorney in Morgan Lewis's DC office. As Jason stated earlier, Allison practices in our Employee Benefits Practice Group. Today we're going to discuss several important topics related to onboarding new employees. We are going to focus on issues that normally arise after an offer of employment is made and then accepted by the employee. It's impossible to cover everything in the 1 hour we have, so Allison and I have focused on several current hot topics in this stage of the hiring process. As you can see from the screen, we'll be discussing the DC Wage Theft Prevention Amendment Act and focusing specifically on the notice requirements under the Act, I-9 compliance, benefits enrollment, and then we'll finish up by reviewing several relevant laws recently passed by the DC Council. One thing we'd like to note before we get started is that we're not providing legal advice during this presentation. Rather, we'll be reviewing what the law requires and best practices on these different topics. So first, let's cover the DC Wage Theft Prevention Amendment Act. The Wage Theft Prevention Amendment Act took effect in February 2015. The Act amended several wage-related employment laws to create a private right of action for employer violations of those laws. That means an employee can initiate a lawsuit in court if they feel that you as an employer have violated that law. It also created employer written notice requirements concerning information related to an employee's wages. That's what we're going to spend the majority of our time focusing on. Just for your general benefit, the Act also enhanced record-keeping requirements for non-exempt employees and created anti-retaliation protections for employees who engage in protected activity. This would most often take the form of an employee questioning their pay or seeking legal recourse to recover unpaid wages. So first off, who's covered under the Act and who does the law apply to? The definitions for the Act are contained in DC's minimum wage law. Employer includes all DC employers except the federal government. Employee includes anyone employed in DC except any unpaid individual who volunteers in the activities of an educational, charitable, religious, or nonprofit organization. Any lay member elected or appointed to office within a religious organization and engaged in religious functions, and any individual employed as a babysitter in the residence of an employer. A couple of notes about these definitions for the definitions of an employee. First, DC's minimum wage law and the DC agency, the DOES, the Department of Employment Services, did not really provide any further definitions or guidance as to what an educational, charitable, religious, or nonprofit organization is considered under this law. However, it's likely that a court analyzing these issues would look to the Fair Labor Standards Act definition of volunteers. Also, for students or interns for educational, charitable, religious, or nonprofit organizations who are not paid, they will not normally fall within this exception. So the crucial distinction for interns is generally whether or not they are paid. The employer notice requirements, as I mentioned earlier, is what we wanted to focus on. Employers must provide each employee with a written notice that contains specific wage information at the following 3 times. First, at the time of hire. Second, by May 27, 2015, for those employees already employed on February 26, 2015, and when any of the required information contained in the notice changes. So the second bullet, as you can see, should no longer be relevant, but for those employees that are covered under this bullet, the effective date is the date the information became current, such as their date of hire or the date they received the salary increase, not the effective date of the law. The individual notice has certain content requirements that must be contained in the notice itself. First, the employer's name and any doing business as names used by the employer. Second, the physical address of the employer's main office or principal place of business and a mailing address if those 2 addresses are different. Next, the telephone number of the employer, the employee's rate of pay and the basis of that rate, the employee's overtime rate of pay or whether the employee is exempt from overtime pay, any applicable living wages, any applicable prevailing wages, and the employee's regular payday. I'd like to note that there are several additional requirements for temporary staffing firms that we're not going to cover today. And for those of you who are unfamiliar with living wages or prevailing wages, those apply to DC government and federal government contractors. The form of the notice is an important thing to keep in mind. The Act requires that every employer provide individual written notice to each employee. The DC Department of Employment Services has provided a notice template on their website. You can see a copy of the first page of that template on the right side of the screen. Even though DOES provided the notice template, employers are permitted to create their own notice form so long as the notice form contains all of the required information. For example, an offer letter often contains or can be easily modified to contain the required information. However, practically speaking, and since a new notice is required anytime any of the identified information is updated, it's often more practical and pretty much easier in the long run to create a standalone form. That way you can just plug in any updates as you go. Another requirement for the notice is that an employer must provide the notice in Spanish if that is the employee's primary language. Again, DOES has provided a notice template in Spanish, and this can be found on their website. The Act also contains a separate posting requirement, and a copy of the poster can be found on the DOES website as well. This poster should be posted wherever other employment posters are posted, such as in the break room. Finally, the notice must be signed by the employee and returned to his or her employer. DOES has clarified that electronic notice and signatures are permitted for this purpose. If the employee refuses to sign, simply note, refuse to sign on the appropriate line, and then date the form and keep it in your records. So now that we've covered the content and form of the notice, I wanted to quickly revisit when notice must be provided. As you'll recall from a couple slides back, notice is required when any of the required information changes. DOES has clarified that an employer must provide new written notice within 30 days of any change to any of the required information that's contained in the notice. For example, an annual salary increase would necessitate updated notice to the employee. This requirement is true even if the change is not initiated by the employer. For example, increases to the minimum wage for minimum wage employees would also necessitate provision of a new notice to those employees. Lastly, the updated notice must include all of the required information, not only the specific information that was updated or revised since the provision of the last notice. Moving on to remedies and penalties. As I mentioned earlier, the Act includes a private right of action for violations of DC's Wage Payment and Wage Collection Law, Living Wage Act, Minimum Wage Revision Act, and Accrued Sick and Safe Leave Act. The Act includes severe penalties, including a fine of up to $10,000 upon conviction for negligent and willful violations of the minimum wage law. And the minimum wage law is the provision which includes the employee notice requirement we just discussed over the past couple of slides. There's also an administrative penalty of up to $500 for each failure to provide each employee with required written notice. Given these penalties, it behooves you to ensure that your organization is up to date on the requirements and has a process in place to ensure that the notice is issued correctly and on time. Next, we're going to discuss I-9 compliance. First, some background. The Immigration Reform and Control Act of 1986 prohibits employers from hiring or continuing to employ workers who are not legally authorized to work in the U.S. Employers must complete a Form I-9 for each new employee hired after November 6, 1986. There are several requirements with respect to the employer completion of the Form I-9s. You should have each new employee complete Section 1 of a Form I-9 on or before the employee's first day of work. However, a new employee may not complete this form prior to accepting the job offer. The employer is responsible for reviewing the original documents presented by the employee to establish his or her identity and employment authorization. We'll review the different types of documents shortly. As an employer, you must complete Section 2 of the Form I-9 within 3 days of the employee's hire. Note that Section 2 must be completed on the first day of work for employees whose employment will last fewer than 3 days. Finally, employers must retain a Form I-9 on file for each current employee for the longer of 3 years from the date of hire or 1 year after the employment ends. I also wanted to point out that the U.S. Citizenship and Immigration Services published a new Form I-9 on July 17, 2017. The revised version must be used for all new hires after September 18, 2017. So any current new hire, you must use the revised form. No real substantive changes were made to the Form I-9. Instead, the new form revised some instructions for clarity and added several documents to the list of acceptable documents that an employee may submit in order to establish their identity and employment authorization. As I mentioned earlier, Section 1 of the Form I-9 must be completed by the employee on or before their first day of work. However, it may not be completed before the employee accepts a job offer. The employer is responsible for reviewing and ensuring that the employee has fully and properly completed Section 1. As an employer, if you find any errors, have the employee make any necessary corrections. And as you can see from the screen, here's a copy of the first page, which includes Section 1 of the Form I-9. Most of the employer requirements are found in Section 2 of the form, which is found on the next page of the Form I-9. The employer must complete Section 2 within 3 business days of the start of the employee's employment. Therefore, it is key that as an employer, you require the employee to provide the required documentation demonstrating their identity and employment authorization prior to this date. Usually, an employee will bring this with them on their first day of work. As you can see on the screen, there are 3 lists of documents an employee can provide: List A, List B, and List C. The employee may provide 1 document from List A or 1 each from List B and List C. It's important to note that the employer may not specify which documents the employee provides. I've listed some examples of the types of acceptable documentation on the screen. However, the Form I-9 instructions provide a complete list of acceptable documents. The employer uses the documentation provided by the employee to complete Section 2 of the Form I-9. And if an employee fails to provide the required documentation within 3 business days, the employee may be terminated. Here is Section 2, so you can see what the employer must complete. As you can see, there are instructions detailing what to fill out and where. Note that in the middle of the screen, you'll see an additional information box. That is where you can provide relevant information that does not fit specifically into any location in the form. For example, you might list employment authorization extensions identified in the documentation provided by the employee, or the date the employee was terminated. This is important and relevant because you elect to retain the Form I-9 for 1 year following the employee's termination. So it's good to have that date on the form. Reverification of employment authorization is required in some instances. There are 2 different tracks for reverification of employee documents. First, current employees. An employer may need to re-verify the employee's authorization to work when certain List A or List C documents expire. As an employer, you must re-verify these documents prior to the date the document will expire. Use Section 3 of the reform to re-verify this document. You can see a copy of Section 3 is found on the bottom of the 2nd page of the Form I-9, and we've copied it at the bottom of the screen for your reference. One thing to note, there's no need to re-verify a U.S. passport, and that tends to be one of the most popular documents provided by employees to establish their employment authorization. Next, for rehired employees, there are 2 courses of action with respect to re-verification of documents for those rehired employees. If an employee is rehired within 3 years from the date of the completion of their previous Form I-9, no reauthorization is required. In this case, you simply provide the rehire date in Section 3 under B, and you can see that in the top right corner of the little image we've put at the bottom of the screen. If the previous Form I-9 indicates employment authorization has already expired, the employer must re-verify the document and provide the rehire date in Section 3, along with the newly submitted documents information. We want to finish up with some best practices concerning completion of Form I-9s. First, do not have different rules or requirements based on an individual's citizenship or immigration status. Next, do not require specific documents. Each individual must be allowed to choose acceptable documentation. Lastly, do not refuse to accept a document or refuse to hire an individual because a document has a future expiration date. Failure to abide by these principles may lead to allegations of discrimination against an employee or applicant, which is prohibited under the Immigration Reform and Control Act. Now I'd like to pass things over to Allison, and she's going to cover some issues related to benefits enrollment and eligibility.
Thanks, Alex. As Alex mentioned, I'm going to be discussing the rules that govern when a new employee must be allowed to participate in an employer's benefit plans. There are separate rules for retirement plans and health and welfare plans, so I'll go through and give a general overview of some of those rules that apply to each of those types of plans. So for retirement plans, there's 2 basic types of broad-based retirement plans. There are those that are called defined benefit plans. These are your traditional pension or cash balance plans. Those have been falling out of favor with most employers as of recent. And the second type are the defined contribution plans. Those are the 401k plans, the 403b plans. For purposes of this presentation, 403b plans are the retirement plan of choice for employees of certain nonprofits or tax-exempt organizations. These plans are generally subject to ERISA and Internal Revenue Code provisions. The 403b plans that are salary deferral only, however, are not subject to ERISA. Only 403b plans that provide matching contributions will be subject to ERISA. However, they are still subject to provisions of the code. 403b salary deferral arrangements must generally be available to all employees. This is what's known as the universal availability requirement. Complying with universal availability means that if an employee is eligible to make elective deferrals, for example, deferring salary into a 403B plan, then all employees, with very few limited exceptions, must be allowed to make elective deferrals. Your organization is also required to provide an annual opportunity for each employee to participate in the plan or change their deferrals. Employees are required to receive notice outlining the date, parameters of their annual elective opportunity. There are also lots of opportunities to do this, such as upon hire, during annual benefits enrollment period, or any other time. It's important to note that employees must be given enough time, however, to make a decision. So what's important to note for this presentation is that ERISA plans do not have to cover all of the employees of the employers that maintain them. This is true of both retirement plans and health and welfare plans. Plans can, by design, be more restrictive, but they have to satisfy certain minimum participation and coverage provisions. They must also satisfy minimum vesting requirements and must ensure that the benefits provided do not impermissibly benefit highly compensated employees. All employees of the company sponsoring the plan and related employers are generally taken into account for plan testing. So we're going to talk about 4 general steps that will help you all identify who will participate in your plan. As we make our way through the list, it'll help eliminate certain individuals from having to be participants. So first is the worker an employee of or leased by the adopting employer. The code doesn't allow just anyone to participate in a qualified plan. First and foremost, the code states that qualified plans are for the benefit of employees, which means common law employees. In addition, the code treats individual partners, sole proprietors, and leased employees, full-time life insurance salesmen as employees who are eligible to participate in a qualified plan. So we have them here to watch out for worker misclassification. The IRS has been concerned with worker misclassification, which relates to the improper classification of employees as independent contractors. Other terms used for an independent contractor include consultant, contract worker, or contractor. Whether an individual performing work is an independent contractor or is really a common law employee is an issue that arises frequently in today's workplaces. It's so frequent, the IRS has implemented 2 initiatives to address worker misclassification issues. The IRS or another federal, state, or local agency may attempt to reclassify these individuals as employees in order to collect employment taxes or provide other work-related benefits. And if an agency or a court determines that an individual has been misclassified, the next issue often is determining whether or not they are eligible for benefits, possibly retroactively. This is why it's so important to properly classify your employees, among other reasons. So to determine whether an individual is an independent contractor or your common law employee, you're going to want to look at the substance of the relationship and not the label that governs their status. There are generally 3 categories to consider in analyzing whether an individual is an employee or an independent contractor. These categories are described in further detail in IRS Publication 15A, called the Employer Supplemental Guide. So the first category is behavioral control. This category focuses on whether the business has the right to direct and control how the worker does the task for which he or she is hired. In particular, the IRS looks at what instructions and training are given by the business to the worker. The more training that's given, the more likely it is that the individual is a common law employee. The second category is financial control. Under this category, the IRS examines whether the hiring entity has the right to control the business aspects of the worker's job. Relevant factors include the extent to which the worker has unreimbursed business expenses, the extent of the worker's investment, the extent to which the worker makes services available to the market, how the business pays the worker, and the extent to which the worker can realize a profit or a loss. The third is the type of relationship. This category considers what written contracts say about the parties' relationship, whether employee-type benefits are provided, the permanency of the relationship, the type of relationship of the parties, and the extent to which services performed by one worker are a key aspect of the regular business of the company. Publication 15A is helpful. It includes many real-life examples to help you determine whether an individual is an employee or an independent contractor. As you can see, no matter how the factors are articulated, The determination of worker status requires an analysis of all facts and circumstances, and no single factor will be determinative. So once you determine that the worker is an employee, a common law employee, or in an eligible class of them, then you have to determine whether the individual is in a class of eligible employees. Without going into too much detail about the code's minimum coverage requirements, since they're very lengthy and complicated, these are some common exclusions in defining the class of eligible employees. It's critical that clear plan language reflects your design choices. The language is especially important when an employer wishes to exclude certain classes of employees. Moreover, plan language should be reviewed periodically to ensure that it reflects current employment practices, as those tend to change over time. And you don't want to be in a situation where you're covering someone that your plan excludes or vice versa. When drafting your plan or contracting with certain individuals, it's important to keep in mind that if any employee in an excludable group is allowed to make salary deferrals into the plan, then all employees in that group must be allowed to defer. This is why it's so critical in making sure you follow the terms of the plan. So after you determine whether an employee is your employee, and if they are in a class of eligible employees, next you can apply some age and service requirements before having to allow employees enter your plan. So for age, a plan is generally permitted to require employees to be at least 21 before they begin participating. There is one exception for certain educational institutions to this rule, but this is the general rule. A plan cannot exclude employees for having attained a certain age. This can also be an Age Discrimination Act issue. But plans can have different plan benefits as long as applicable non-discrimination requirements are satisfied. Moving on to minimum service requirements, in general, a plan may require employees to complete up to 1 year of service before they begin their participation in the plan. There is an exception that permits a plan to require employees to complete 2 years of service before beginning participation in plan benefits other than elective deferrals, but only if the employees have a 100% vested right in all plan contributions made on their behalf immediately upon their participation. As with the age requirement, a plan may have different service requirements for different plan benefits so long as applicable non-discrimination requirements are satisfied. So finally, after you determine whether your employee is your common law employee, if they are in a class of eligible employees, and if they've met any applicable age and or service requirements, the final category before you have to let them in is determining whether the employee is still employed on the plan's entry date. ERISA and the code both require that plan participation must begin no later than the earlier of the first day of the plan year following the employee's satisfaction of any minimum age and service requirement, so age 21 and 1 year of service, or the date that is 6 months after the satisfaction of the minimum age and service requirements. Plans can have more frequent entry dates, for example, the first day of the calendar quarter or the first day of the calendar month, and participants generally appreciate having more frequent entry dates. However, we do note that that could be more burdensome to administer. So it is important to make sure you have at least the minimum required by ERISA and the code. So as I mentioned, it's really important to make sure that employees are enrolled when they should be enrolled and that the terms of the plan are followed. Because if someone is enrolled who is not eligible, that could open up the whole class to being required to make salary deferrals under the plan. So you want to make sure that you adopt and document proper procedures for enrolling individuals and distributing employee election forms. The 403B written plan document must contain material terms and conditions for eligibility, and it must clearly state who may elect to make salary deferrals and who is excluded. For those 403B plans that are subject to ERISA, the SPD must be sent within 90 days of eligibility. And this is great because it puts employees on notice of their participation rights. A helpful way to ensure that employees aren't mistakenly excluded is to use election forms that require a response. This way, even if the employee elects not to participate, some action is still required on their part to get the form back to you, so you know that they have affirmatively elected not to participate in the plan. And it's helpful to retain proof of distribution in case an issue arises later when an employee challenges whether or not they were provided the opportunity to enroll. Now, of course, even best laid plans come with mistakes. So if you make mistakes with respect to your plan, the IRS has the Employee Plans Compliance Resolution System, or EPCRS, and that is available to help you remedy any mistakes and avoid consequences of plan disqualification. So in the case of a 403B plan, the consequences of disqualification of both the 403B annuity contracts or the employee's custodial accounts in this case. A correction for a mistake should be reasonable and appropriate and take into account all facts and circumstances. It could go so far as to restoring the participant's lost opportunity and or their missed deferral. Revenue Procedure 2016-51 is current guidance governing the EPCRS program. Generally, there are 3 ways to correct mistakes under EPCRS. The first is the self-correction program. This permits the plan sponsor to correct certain plan failures without contacting the IRS or paying any fee. The next is the voluntary correction program, and this permits the plan sponsor to, at any time before an audit, pay and receive IRS approval for correction of certain plan failures. Finally, there's the audit closing agreement program, and this permits the plan sponsor to pay a sanction and correct a plan failure while a plan is under audit. So most importantly, with respect to these retiree plans, we want to make sure that employers know the terms of their plan and follow the terms of the plan. This will help avoid any compliance issues. So moving on to health and welfare plans. Similar to retirement plans, ERISA does not dictate eligibility provisions for health and welfare plans, and plan sponsors generally have broad discretion to determine who is eligible for plan benefits. However, while plan sponsors generally do have wide freedom to determine plan eligibility under ERISA, there are certain tax considerations and other laws that prohibit certain forms of discrimination, and these can have a profound effect on plan design in terms of eligibility. Also, the Affordable Care Act now imposes certain eligibility requirements on affected ERISA group health plans. So things that you all should consider. I want to highlight covering individuals who are not tax code dependents of the employees. So for example, domestic partners, certain children who exceed the age limit for tax advantage coverage, so those who are over age 26 and not disabled. Many ERISA health and welfare benefits can be provided to employees, and in some cases, former employees, and their spouses and dependents on a tax-free or tax advantage basis. But while welfare plan sponsors are generally free to define eligibility requirements to include individuals who are unlikely to qualify for tax advantage coverage, like the domestic partners and certain adult dependent children, there are additional tax compliance obligations that will be created by doing so. So for example, you might have to impute income to employees for the affected individuals, withhold income taxes, and pay employment taxes with respect to their coverage. When designing eligibility provisions, it is important to carefully consider the impact of these tax issues on employees and also your own tax compliance. So moving on to the non-discrimination rules. As a condition of receiving favorable tax treatment, the code also requires that certain plans and benefits not discriminate in favor of particular groups of employees. These are the highly compensated employees, the key employees, and owners. These non-discrimination requirements apply to group life insurance plans, self-insured medical plans, cafeteria plans, also known as Code Section 125 plans, flexible spending accounts, and benefits that are provided through Aviva. When designing eligibility provisions for these plans, you should be careful not to inadvertently cause a plan to discriminate in this manner. And for many of the non-discrimination rules, there are design-based ways to avoid these kinds of non-discrimination problems, and those rules can be built into the plan document itself. At this time, fully insured employers are still able to offer more generous benefits to executive employees as part of their total compensation package, either a separate plan for senior managers, shorter waiting periods for these individuals for eligibility, and lower employee contribution for these types of senior managers and highly compensated employees. And while this is allowed right now, if you have an insured group health plan, these plans may eventually be required to comply with non-discrimination requirements under the Affordable Care Act. However, those requirements will not go into play until regulations have been issued, and they have not been issued yet, and there is no indication from the administration that they will be issued anytime in the near future. There are also many other federal laws that impact the way employers design their plan eligibility rules. Some of these laws apply with respect to particular types of benefits, mainly group health plans, while other federal laws apply more generally to the employer-employee relationship. So for example, HIPAA prohibits discrimination under certain group health plans on the basis of health status-related factors. But in addition, employers and their plans might be subject to other generally applicable laws like federal civil rights laws that restrict eligibility decisions based on legal distinctions such as age, race, sex, or disability. The HIPAA non-discrimination rules do not get into those kinds of factors. For fully insured plans, most insurance policies will defer to the employer to define who is eligible, but some state laws also might impose some specific eligibility requirements. These requirements are generally outlined in your insurance policy. Finally, I'll give an overview of some of the healthcare reform requirements, which we'll get into in the next upcoming slides. In addition to the extension of the non-discrimination requirements to insured plans, the Affordable Care Act impacts group health plan eligibility and enrollment in several significant ways. So I'm going to be talking in general about the Affordable Care Act rules that impact eligibility and enrollment. They're laid out on this slide, and we're going to be discussing some of these rules in more detail on the next few slides. These are just some highlights. The Affordable Care Act contains a lot of rules and a lot of detail, and we're not going to have time to get into all that detail today, but I did want to highlight the most important considerations. So the Affordable Care Act rule that's probably gotten the most media attention and that you all are most familiar with, especially if you work for a larger organization, is the employer mandate. And these are the employer shared responsibility provisions. The employer mandate requires that applicable large employers, so those are employers with 50 or more full-time employees and full-time employee equivalents, so 2 part-time employees would be a full-time employee equivalent, for example. The employer shared responsibility provisions require those large employers to offer health coverage that meets certain requirements to their full-time employees and those employees' dependent children, or pay a tax penalty. There are 2 tax penalties, and both tie to whether qualifying coverage is offered to full-time employees, and if a full-time employee who is not offered coverage receives a premium tax credit for individual coverage that they received on an exchange or in the healthcare marketplace. The other ACA requirements actually affect the employer's group health plan itself, so these rules are not limited to large employers. Some of these rules overlap with the employer shared responsibility requirements, but there are differences which can make compliance challenging if you're a large employer because you have to navigate where the rules converge and then where they differ. The most direct requirement on group health plans and insurers that offer those that offer dependent coverage have to make such coverage available for an employee's child until the child reaches age 26. The other requirement is that most group health plans cannot apply waiting periods that exceed 90 days. And finally, the Affordable Care Act's prohibition against rescissions comes into play when discussing eligibility, since those rules restrict the ability to retroactively cancel an individual's coverage unless there's fraud or intentional misrepresentation. The rescission rules really serve to highlight the need to have clear eligibility provisions in your plan documents and adhere to good enrollment procedures, since once you find someone's getting coverage under the plan when they shouldn't be, you can only cancel their coverage on a prospective basis in most cases. These requirements for group health plans and issuers apply to most major medical plans for active employees. Retiree-only plans, standalone dental, vision, and other accepted benefits do not have to comply with these rules. However, we do note that lots of employers do apply these provisions to those kinds of plans so that they have a general consistent eligibility provision across the board. Failure to comply with these plan rules can also result in per-day excise tax penalties, which, while they don't seem as significant as the employer shared responsibility penalties, they do add up over time if there's a history of noncompliance. The Affordable Care Act employer shared responsibility rules require that applicable large employers offer coverage meeting certain requirements to their full-time employees. As I mentioned earlier, the penalties are triggered when those employees specifically don't get coverage and receive subsidized insurance on an exchange. So first of all, who is an employee? And similar to with the retiree plans, employee is under the common law standard. So independent contractors are not employees for this purpose. Again, worker misclassification is very important here. To the extent an individual is misclassified as an independent contractor when they are a common law employee, and they could trigger a penalty for your organization. So once you've determined you have a common law employee, the next is, are they full-time? And for ACA purposes, this means an employee who's employed an average of 30 hours a week or 130 hours a month. I will note the employer shared responsibility regulations under the ACA go into a lot of detail on how to count an employee's hours of service, and that detail is beyond the scope of this presentation. In general, however, an hour of service for ACA purposes is each hour for which an employee is paid or entitled to payment for the performance of duties, and each hour for which the employee is paid or entitled to payment by the employer for a period of time during which no duties are performed due to vacation, holiday, illness, incapacity, which includes disability, layoff, jury duty, military duty, or leave of absence. This is very important because it's not just when an employee is actually working or scheduled to work. For hourly employees, all of these hours must be counted in determining whether they've worked 30 hours a week or 130 hours a month. For non-hourly employees, however, the regulations provide you with the option of using their actual hours or an equivalency of 8 hours a day for every 1 hour worked that day, or 40 hours a week for every 1 hour worked that week. Note that special unpaid leaves under FMLA, USERRA, and for jury duty are included for purposes of counting hours of service. So a big question comes up a lot of times when individuals are provided by a staffing agency. Sometimes it's unclear whether they are your common law employees as the employer, or if they are the common law employees of the staffing agency. Due to the IRS's uptick in worker misclassification and also the ACA employer shared responsibility rules, it's very important to make these distinctions and come out the right way. So when there's a question, the regulations will allow the client employer to treat certain staffing agency offers of coverage as made by the client employer. If the staffing agency does make qualifying offers of coverage, then that offer is treated as having been made by the client employer for employer shared responsibility purposes, as long as the fee the client employer would pay to the staffing agency for the employee who enrolls in health coverage under the staffing agency's plan is higher than the fee the employer would pay the staffing agency for the same employee if that employee did not enroll in health coverage under the plan. So essentially, this rule allows an employer who leases an employee through a staffing agency to take advantage of the staffing agency's offer of coverage, as long as through the contract, the employer pays more for that individual. So as a practical matter, it means that as an employer, if you use leased employees from a staffing agency, you'll have to contractually protect yourself from the unexpected and potentially costly employer shared responsibility consequences that could result from using these staffing agency workers to the extent they are later classified as your common law employees. Contracts with staffing agencies should be amended to require, among other things, that staffing agency commits to ensuring that it is a common law employer of the individuals in question, that it provides qualifying coverage to individuals in question and satisfies all other employer shared responsibility requirements as if the individuals were common law employees of the staffing agency. It should also represent and warrant that the fee the client would pay the staffing agency for an employee who enrolls in their health coverage under the plan is higher than the fee the employer would pay the staffing agency for the same employee if that employee did not enroll in health coverage under the plan, and indemnify and hold harmless the client employer from any breaches of these requirements. At this point, it's unclear what fee is a higher fee, whether it's $1 or $100. As long as it's higher, it seems that fee is appropriate. But it's also equally unclear if paying less for an employee who rejects coverage is also permissible. To be safe, your contract terms should dictate that a higher fee is paid. So the next topic that gets a lot of attention is coverage of dependents, and specifically dependent children. The employer shared responsibility rules require that employers offer coverage to full-time employees and their dependents. And then separately, the Affordable Care Act mandates that coverage of dependent children be provided until the dependent reaches age 26. So I'll talk about these separately, and then we'll talk about them, how they interact. Under agency regulations, dependent coverage means coverage of any individual under the terms of a group health plan or a group or individual health insurance coverage because of their relationship to the participant. This means that you can only define who is a dependent in terms of whether they are your child, biological, adopted, stepchild, and you cannot define dependents as a dependent for tax purposes based on student status or anything like that. The DOL has, and IRS and HHS have said that you can use the code definition of child as a safe harbor, but factors such as residency, age, income, and marital tax filing status are not permitted eligibility conditions, regardless of whether the child is a minor child or an adult child. So the code definition that the tri-agencies allow as a safe harbor includes sons, daughters, stepsons, stepdaughters of the taxpayer, and eligible foster children. In addition, the coverage that is available for children under age 26 cannot vary based on age. This is called the uniformity requirement. So the terms and conditions on which dependent coverage is provided to children cannot vary based on the child's age unless the child is 26 or older. For enrollment purposes, this means a surcharge for the coverage of adult children is not allowed unless it applies regardless of the child's age up until age 26. So you cannot charge a child who is under 18 more for coverage than a child who is age 18 to 26. Also, the plan can't vary benefit packages based on the age of the child. So you can't offer your PPO plan to your dependent children who are 18 or under, and then your high deductible plan to your children ages 18 to 26. Those kinds of things would not be permissible. So as previously discussed, so those are the rules for dependent children to age 26, but employer shared responsibility requires coverage be offered to full-time employees and their dependents, or they have to pay a penalty. And those rules define dependents to include children, biological and adopted, up to age 26, but not spouses, grandchildren, qualifying relatives, foster children, or stepchildren. So there's a little disconnect in the definition of dependent for this purpose. In general, if you are a large employer subject to the employer shared responsibility rules, it might behoove you to cover the stepson and stepdaughter of the taxpayer in order to make sure that you comply with both requirements. The ACA also prohibits group health plans and issuers from applying a waiting period that exceeds 90 days. A waiting period is defined as the period of time that must pass before coverage for an individual who is otherwise eligible to enroll under the terms of the group health plan can become effective. Final regulations permit plans to impose eligibility criteria, but require participation within 90 days of meeting such criteria, and such eligibility criteria cannot consist solely on the lapse of time. The waiting period generally cannot extend beyond 90 calendar days. All these days are counted, including weekends and holidays. So this is not a 3-month rule. Some plans might find it simpler to adopt a 60-day or a 2-month rule in order to make sure that they comply with the waiting period rules. The regs also, however, provide for a bona fide orientation period, which would be a substantive eligibility condition, and allow individuals who are otherwise eligible to enroll to get an extra month to have to comply, and that pushes you to the 3 months. The employer shared responsibility requirements also require that coverage be effective by the first day of an individual's 4th month of employment. So there's some tension there for large employers that have to comply with both rules. There are also 2 alternatives to the 90-day requirement. Plans can impose a 1,200-hour rule if they condition eligibility on an employee's either part-time or full-time having completed a number of cumulative hours of service. The waiting period must begin on the first day after the employee satisfies the plan's cumulative hours of service requirement and cannot exceed 90 days. Further, this provision continues to be designed to be a one-time eligibility requirement only. So the rules don't permit, for example, reapplication of such a requirement to the same individual each year. It can only be applied one time. For variable hours employees, the agencies have provided an approach when applying waiting periods as a plan eligibility condition. And under the regs, if a group health plan conditions eligibility on an employee regularly having a specified number of hours of service per period or working full-time, and it cannot be determined that a newly hired employee is reasonably expected to work that number of hours or work full-time, then the plan can take a reasonable period of time to determine whether the employee meets the plan's eligibility condition, which may include a measurement period of no more than 12 months. This is consistent with the employer shared responsibility rules, and coverage must be made effective no later than 13 months from the employee's start date. Plus, if the employee's start date is not the first day of the calendar month, the time remaining until the first day of the next calendar month. So to wrap up, it's very important, once again, to document your eligibility requirements in your health and welfare plans. ERISA requires welfare plans to be established and maintained pursuant to a written instrument that describes the rights and obligations of persons covered by the plan. Since eligibility rules do affect basic plan rates, those requirements must be documented in order to satisfy this rule. The SPD also must address exceptions and limitations that can result in the loss or denial of benefits, which would include eligibility. And it's important to note that slight differences in eligibility descriptions can make a significant difference in who is deemed eligible. So make sure your less formal benefit descriptions and any enrollment materials or offer letters are consistent with the terms of your more formal plan documents. So once again, know your plan and follow your plan terms. And now I will turn it back to Alex to finish up.
Thanks, Allison. As I mentioned at the very beginning of our presentation, the DC Council has been fairly active over the past couple of years with respect to employment-related laws. Several of these laws are important from a hiring and onboarding perspective. In our remaining time, I will briefly cover relevant aspects of the Fair Criminal Record Screening Act, the Fair Credit and Employment Act, and the Universal Paid Leave Act. First, the Fair Criminal Record Screening Act, which is also known across the country as a ban the box law. The act became effective on December 17, 2014, and it applies to all private employers in DC with more than 10 employees. The act prohibits inquiring about or requiring an applicant to disclose a criminal arrest or conviction until after extending the applicant a conditional offer of employment. It also prohibits inquiring about or requiring applicants to disclose any arrest or criminal accusation which is not currently pending. There are several exceptions to the prohibitions, which you can see identified on the screen. The one that I wanted to focus on quickly is the last one, any facility or employer that provides programs, services, or direct care to minors or vulnerable adults. It's important that you note that the actual position in question must provide the programs or services to qualify for this exemption. An organization does not get a pass company-wide because the organization generally provides these services. So, for example, the prohibition still applies to a janitorial position even though the organization provides these types of services. The Act provides that an employer may only take adverse action against an applicant on the basis of his or her criminal record for a legitimate business reason. And the Act outlines 6 factors that should be considered in making such a determination. As you can see, I've provided these 6 factors on the screen. And in short, an employer must be able to provide a concrete, legitimate business reason for the adverse action. As for remedies and penalties, there's no private right of action under the Act. Instead, an individual alleging misconduct must file an administrative complaint with DC's Office of Human Rights. Administrative penalties are based on the size of an employer. So if you have 11 to 30 employees, you receive a $1,000 penalty. 31 to 99 employees results in a $2,500 penalty, and 100 or more employees results in a $5,000 penalty. Importantly, half of the penalty goes to the complainant while the other half goes to the district government. This format has essentially established a bounty, and serial filers who have no interest in actual employment. These individuals seek out employers with non-compliant application forms. And since it's usually a facial violation, there's not much an employer can do. As for recommended steps for compliance, make sure that you update your online and paper applications. Review the hiring process and ensure that your HR employees and interviewers are aware of the requirements and prohibitions under the Act. Next is the Fair Credit and Employment Act. The Act took effect on April 7, 2017. It amended the D.C. Human Rights Act to prohibit employers from discriminating against employees and applicants based on an individual's credit information. As a result, one's credit information is now akin to a protected characteristic under D.C. law. The Act prohibits employers from asking employees or applicants for credit information, using credit information, or accepting, referring to, or inquiring into an employee's or applicant's credit information. Note that inquires defined pretty broadly under the law and includes obtaining credit information on application forms or interviews and conducting credit history checks. The Act contains several exceptions, which you can see listed on the screen as well. With respect to penalties and remedies, the Act provides for a private right of action as well as the ability to file a complaint with OHR. Note that the private right of action exists because this is now a violation of the D.C. Human Rights Act. Penalties are based on the number of employer violations: $1,000 for the first violation, $2,500 for the second violation, and $5,000 for each subsequent violation. This time, the fine goes entirely to the charging party. Like D.C.'s ban the box law, the Act provides for the complainant to collect the penalty, but like I said, this time the complainant would receive 100% of the penalty. Employers should be aware that this is likely to incentivize individuals to file a charge or even possibly file a lawsuit. As for recommendations for compliance under the Act, employers should review their employment applications for any references to credit checks. Make your HR employees aware of the Act's requirements so they don't mistakenly direct a course of action that creates liability. And also discuss these requirements with any third-party vendors you may have who conduct these types of services. Lastly, I'd like to discuss the Universal Paid Leave Act. The Act became effective on April 7, 2017. On that date, D.C. became the 8th jurisdiction to enact paid family leave. However, D.C. is the first to do so in a manner that is 100% employer-funded. The previous jurisdictions required some form of employee contributions. Some details surrounding the Act are still uncertain. For example, even though the Act was passed and is now law, there are several bills percolating in the Council to amend various portions of the Act. These amendments mostly concern finding alternatives to the funding structures that was passed. However, it's not inconceivable to see some benefits reduced if the current structure can't pay for the benefits as currently authorized. As for those benefits, they provide for 8 weeks of paid parental leave for childbirth or placement, and parental leave must be taken within 1 year of the qualifying event. 6 weeks of paid family leave to care for a family member's serious health condition, and 2 weeks of paid medical leave to care for one's own serious health condition. However, there's a total cap of 8 weeks in any 52-week period. That means that no matter how you divvy up the leave and for whatever reasons one takes the leave, no one is entitled to more than 8 weeks total of paid leave. Also, the leave runs concurrent with any leave taken under the FMLA and DC FMLA, so you don't get to double dip in that sense. As for who the Act applies to, any employee who works more than 50% of their time for a private employer in DC is eligible for the paid leave benefit. This includes DC employees who reside in Maryland as well as Virginia. There's also no carve-out for small employers. Employees who work a substantial amount of time in DC, but not more than 50% of their time in another jurisdiction, are also covered. With respect to the payment of the benefits, employees who earn less than 1.5 times the minimum wage will receive 90% of their weekly wages. Employees who earn more than 1.5 times the minimum wage will receive 90% of their weekly wages up to 1.5 times the minimum wage, and then 50% above that threshold. However, the benefits are capped at $1,000 per week, and the cap is supposed to increase annually beginning in 2021. As for funding the leave, these are where most of the issues surrounding the Act currently reside. The DC government is supposed to establish a new agency to administer the Universal Paid Leave Fund. However, no infrastructure currently exists to administer the system, so it will have to be built from scratch. The council chairman indicated it might take as long as 18 months to set this process up. Covered employers will make a mandatory contribution of 0.62% of the wages of its covered employees into the fund. So, for example, an employer would make a required contribution of $6.20 into the fund for every $1,000 of employee salary. The employer mandatory contribution was originally supposed to be 1% of all wages, but after some negotiations was reduced to 0.62%. Also, as originally contemplated, the fund is supposed to be similar to an unemployment insurance fund. There are questions as to whether the 0.62% contribution will be enough to cover the output that will be required to fund the leave. For example, DC's own CFO noted in his fiscal impact statement that adequate resources have not been fully identified nor appropriated to cover the startup and implementation costs associated with the Act, and thought that these costs could reach as high as $80 million. The DC Council has introduced several new bills attempting to amend the Act after it was passed. None of these bills change the amount of paid benefits provided. One attempts to eliminate DC's administration of the leave by providing an employer mandate where employers would administer the leave themselves within certain general requirements, similar to how DC's current paid sick leave law operates. Another attempts to reduce the employer mandated contribution to closer to 0.5% of an employee's wages. These issues will continue to be addressed through this council session. As for the timing, employers are supposed to begin making payments into the fund beginning in 2019, and the mayor is supposed to provide additional details on this process in early 2018, so be on the lookout for that information. Employees are supposed to begin accessing the paid leave in 2020. Similar to some of the other laws, the Universal Paid Leave Act contains a notice requirement, and this applies to all individual employees. Employees must be provided notice on 3 separate occasions. First, at the time of hire, second, on an annual basis, and third, whenever the employer becomes aware that the leave is needed. Similar to the wage theft notice, the DC government will provide a notice template for employers to provide to their employees. And the notice is supposed to contain the following information: the employee's right to paid leave benefits under the Act, that retaliation by an employer against an employee for requesting, applying for, or using paid leave benefits is prohibited, that an employee who works for an employer with under 20 employees is not entitled to job protection if he or she decides to take paid leave, and that the covered employee has a right to file a complaint, as well as the procedures established by the mayor for filing a complaint. Lastly, the Act also contains a posting requirement, and the DC government will provide a poster at some point this year as well. As for penalties and remedies, there's a fine of up to $100 for each employee to whom individual notice is not provided, and a separate fine of up to $100 for each day the employer fails to post the notice. So that's all we have for you today. Thanks so much for listening. And with that, I'd like to pass the floor back over to Jason.
Great, thanks all. We're a little over time, but just wanted to clarify very quickly on that last point. The Universal Paid Leave Act, the notice and posting requirements, these are the requirements that are going to apply once the DC government passes regulations and comes up with the template forms. So these aren't something that employers have to worry about today, but it's just something that they should know is coming down the pipe. Is that right?
Exactly, yeah. The DC government will provide a template. They have not yet, and once they do, there'll be more information on that.
Great, and we had some questions all along this one theme, which is for those attendees who are not DC-based employers, how does today's presentation sort of break down for them? What applies and what is state-specific?
So unfortunately, there's not really a universal answer to that question because each law defines employee and employer differently. You'll have to look to see how you fall into those requirements, and that will determine the basis for whether these requirements will apply to you.
For purposes of my part of the presentation with respect to benefits, those are all federal requirements, so those should apply irrespective of whatever state the employee is in. Although I will note that employers that have fully insured group health plans, those plans generally comply with certain state laws, but I didn't talk about those laws because, again, they vary by state and are in the policy.
Right, and the section on I-9 compliance would also be federal law, and so should also apply broadly.
Exactly, yes, that's correct.
Yeah. And then one last specific question about the first section, the DC wage theft prevention notice requirement. So if an organization recently moves to DC, are they required to provide the notice to their current employees?
Yes. You should provide that notice to your employees. You can date it, as I mentioned, it wouldn't be the date that you moved or the date that the current information took effect. So whatever it was, that last pay increase or something like that.
Mm-hmm. Okay, got it. And as a high-level note, the DC Wage Theft Prevention Act just applies to DC-based employers. So if you're an employer based in California, the act does not apply?
Again, it depends on where your the definition of employees and employers. So you'd have to check that.
Got it. Okay, well, great. Thanks so much. If there are any other specific questions, you can put them in, and we'll see if we can have some answers to you directly. And as I mentioned, the presentation for today can be downloaded under the Handouts tab of GoToWebinar. So take a look at the web platform that you use to get the dial-in information, and you should find a link to the handout information there. Okay, great. Thanks, Alex and Allison.
Thank you.
Thanks, guys.
Great. Have a good afternoon. Bye.